If you're a lawyer, you want to become a lawyer, you employ lawyers, you supervise them, you love a lawyer, you need a lawyer, or maybe you're currently trying to act as your own lawyer using AI, this episode is for you. Because something bigger than law students are stressed and the profession is in trouble is happening right now. Law schools are trying to train future lawyers at the exact moment that human attention, professional identity, public trust, and even the meaning of expertise itself are shifting underneath them. Meanwhile, millions of people who can't afford legal help are turning to AI for their contracts, their court filings, their employment disputes, their leases, their immigration issues, especially now, and business decisions without really understanding how often these systems can sound convincing while being dangerously wrong. And the profession, the legal profession, is caught in the middle. Today, we're going to talk about what I'm seeing inside law schools, why so many students struggle cognitively and emotionally and they seem overloaded, what neuroscience tells us about stress and learning, what the CLEAR report says about the widening gap between legal education and actual practice, why courts and judges are increasingly worried about AI hallucinations in legal work, how practicing lawyers and even some of the biggest firms in the world have already been caught filing fake citations, what non-lawyers need to understand before relying on AI for legal issues, and a practical framework for protecting your own attention in a world designed to fracture it. So welcome to Leadership, Law, and Lightwork. I'm Marcia Narine Weldon. This episode is sponsored by Illuminating Wisdom, where leadership, neuroscience, law, communication, and responsible AI come together to help high responsibility people think more clearly, lead more effectively, and function more sustainably under pressure. I've been teaching law students for 15 years, and something has changed in the classroom. I see it in the deadline emails. I need an extension. I see it in the request to keep cameras off. I see it in the number of students who describe having a bad day when what they really seem to mean is that their entire system feels flooded and overloaded. I see it when students have multiple deadlines at the same time and they can't figure out where to even begin, even though they're intelligent, they're thoughtful, they're clearly trying hard. I see it during oral simulations when a student who has prepared and they've prepared reasonably well, they suddenly start to cry because the follow-up questions feel threatening instead of developmental. And honestly, I think a lot of people are misdiagnosing what's really happening right now. And at the same time, our emails are summarized for us. Articles come with a TLDR section. AI gives us answers before we fully wrestle with the questions ourselves. And we're increasingly operating inside systems that reward speed, compression, reaction, and output instead of sustained attention, ambiguity tolerance, deep reading, or careful analysis. So the stress is the visible symptom. The deeper issue is what happens when declining human attention collides with persuasive machine-generated output inside of a profession that still depends on our human judgment. So the leadership issue I want to talk about today in the Leadership Lab is capacity. I think a lot of highly educated environments are confusing cognitive overload with laziness, disengagement, fragility, or maybe even a lack of professionalism. And those aren't always the same thing. Law school has always been demanding. The profession has always required discipline and analytical rigor and emotional control and the ability to function under pressure. None of that is new. And I'm not arguing for lower standards. I'm asking whether the structures we inherited still produce the kind of thinking the profession now needs. And that is a different conversation. The students entering law school now grew up in a very different cognitive environment than earlier generations like the one I'm part of. Many of them went through their formative educational years during COVID. Many of them learned through screens, through periods of isolation, uncertainty, fragmentation, and disruption. Some missed internships, the mentoring, the networking, the structure, the social development, just the ordinary experiences where people slowly build their professional confidence. And a meaningful share of current law students are also first-generation students, which has always been the case, but it matters even more now. If you're the first person in your family to go to law school, you're often learning the doctrine and the hidden curriculum at the same time. You're trying to figure out what professors expect, how recruiting works, what counts as a strong internship, how networking works, how to speak professionally, when to ask for help, what mistakes are normal, what mistakes might feel catastrophic but really aren't. That creates a cognitive load before we even get to the casebooks. And then recruiting starts almost immediately now. Students barely begin adjusting to legal analysis before grades start carrying even more enormous emotional weight. Then come the conversations about journals, on-campus interviewing, clerkships, callbacks, networking, LinkedIn, prestige, and whether one exam is going to shape the trajectory of the career. The pressure changes shape over time. First year often feels like just survival. Let me just get through it. Second year becomes this strange combination of opportunity and exhaustion. Students are juggling journals, clinic, moot court, interviews, leadership roles, internships, networking events, classes, jobs, and constant comparison. And by third year, there's another layer of anxiety that often appears. Some students have jobs, but they're terrified they're not going to perform well once practice starts. They don't feel prepared. Others don't have jobs yet, and they feel maybe even ashamed or panicked about that. I hear it all the time. Some are watching AI transform entry-level legal work and wondering whether the profession they trained for is already changing underneath them. And then the bar exam starts looming over everything. There is another layer here too. Some professors are now saying that college students and law students are arriving having never really practiced sustained reading at the level of difficulty that older faculty members assume is normal. And I see a version of this in law school. Many students aren't reading full cases across all of their classes. They're using summaries, excerpts, commercial briefs, which I did too, okay? AI outputs, group chats, just to survive the workload. And I understand why they do it. We all did it. But legal reasoning develops through the slow work of reading messy facts, procedural history, judicial language, dissent, ambiguity, and that uncomfortable middle where you don't really fully understand it yet. Older professors, maybe more seasoned professors, we often developed our reading habits in a completely different attention environment. There were 3 television channels, 3 networks, a few major newspapers. The news came on at certain times of day. There was no social media feed. There wasn't a phone in our hand every few minutes. There was no AI summary waiting beside the assignment. So today, students are living inside a different attention economy entirely from their professors that are teaching them. And the research on whether smartphones and social media directly cause anxiety is genuinely contested, so I'm not going to overclaim it. But what's not in dispute is that the attention environment has changed, and that the conditions that once built deep reading, fewer inputs, longer stretches of uninterrupted thought are mostly gone. So when a student freezes during a cold call, we need to think more carefully about what may actually be happening. Maybe the student didn't prepare. That's plausible, it's likely sometimes. Maybe the student prepared using tools that gave them recognition without retrieval. Maybe the student understood the summary, but never built the deeper mental model. And maybe the room itself felt like public judgment, and the brain shifts into threat mode. Cold calling can absolutely help students learn composure, listening, retrieval, and real-time reasoning, what happens in the real world. And used well, it can be completely valuable. But used carelessly, it can teach students that learning happens through humiliation. And these are not the same educational experience. A challenged brain can learn. A threatened brain often protects itself instead. And then we built entire semesters in certain classes around one high-stake exam. And when we're surprised when students treat every class like a referendum on their worth. One exam can reward synthesis and discipline, but can also distort learning when students spend 14 or 15 weeks trying to predict what's going to matter on one day, instead of actually learning what's going to matter for a lifetime. Then after 3 years, many students face the bar exam, another enormous high-stakes assessment that determines whether they can work, earn money, and begin the professional life they borrowed so heavily to pursue. So schools might offer counseling and accommodations and extra time and wellness programs and academic support, and those resources are critical. But the workplace is not always going to offer the same supports. A client deadline may not move because someone is overwhelmed. A judge may not care that a lawyer has 3 emergencies that week. A partner may not explain the assignment twice. A founder may not know what legal question they should have asked before signing something important. So support matters, but training matters too. And students need to learn how to regulate under pressure, retrieve under pressure, communicate under pressure, ask for help early, use AI responsibly, and build the kind of stamina that actual practice requires. One of the phrases I use in my work with law firms and others is, you're not training rested brains, you're training stressed brains. And once you really understand that, legal education has to look different. The prefrontal cortex is heavily involved in reasoning, planning, judgment, impulse control, holding competing possibilities in mind, the CEO of your brain. The hippocampus helps with memory formation and retrieval. The amygdala scans for threat. When the brain increasingly perceives the environment as overloaded, as evaluative, as unpredictable, as threatening, resources begin shifting. People can still be intelligent while losing access to that intelligence under pressure. Retrieval becomes harder, though. Working memory narrows. Ambiguity tolerance drops. Emotional reactivity increases. And feedback starts feeling dangerous instead of developmental. That's why a student can understand material perfectly alone in the library and then struggle once the interaction itself starts feeling evaluative. And honestly, I think legal education is hidden behind tradition for way too long. We inherited structures from a very different era and often treat them as synonymous with rigor simply because they're just familiar to us. Meanwhile, the cognitive environment outside the classroom changed dramatically. I've watched students rely on summaries because they no longer trust their ability to sustain attention throughout the full opinion. I've watched students panic over networking emails or networking phone call because every interaction feels professionally permanent to them. I watched them reach for AI because staring at a blank page suddenly feels unbearable. And I'm not saying students are broken. I'm saying the environment changed faster than many institutions did. And part of why I'm leaving academia is because I increasingly felt the call to work on larger structural problems, shaping legal education, leadership, AI governance, professional identity, and human decision making. But the issues now reach far beyond a single classroom, especially because I also train frontier AI models and spend significant time evaluating how these systems perform on complex reasoning tasks. I see how powerful they are, and I see what's missing. I see how persuasive they can sound even when they are dead wrong. And I think legal education, the legal profession, the regulatory systems are entering a period where they need to rethink what competence actually means. The future lawyer may need stronger verification skills, better judgment under uncertainty, greater emotional regulation, and more cognitive endurance than many people have expected. And if anything, I think the future may require deeper forms of human judgment, but we may need better ways to develop it. And I think that educators and regulators, employers, bar leaders need to start asking the harder questions. Are we training students to memorize information or to reason carefully? Are we teaching people how stress affects judgment? Are we teaching verification skills explicitly? Are we helping students build the attention stamina that they need? Are we teaching people how to think with AI without surrendering their judgment to AI? Because the profession still desperately needs excellent lawyers, and probably now more than ever. And that brings me to the brief. For today's brief, I want to use the 2025 report from the Committee on Legal Education and Admissions Reform, known as CLEAR. CLEAR was created by the Conference of Chief Justices and the Conference of State Courts, the administrators, and they wanted to examine legal education, licensure, practice readiness, public trust, and the justice gap. They released it on July 30th, 2025, so almost a year ago. But it's useful because it doesn't just treat legal education as a private law school problem. It frames the issues as a public protection problem, a justice problem, a court system problem. State courts handle 70 million filings every year. Roughly 98% of all litigation in this country, in the United States, happens in state courts. And large numbers of people navigating them are doing without lawyers because they can't afford legal help. So the report discusses the access to justice crisis directly. Low-income Americans receive no help or inadequate help for 92% of the civil legal problems that substantially affect them. 92%. Legal aid organizations have to turn people away constantly because there are not enough resources. There are 1.3 million lawyers in this country, and only about 10,000 of them focus full-time on doing legal aid work. This means this episode matters even if you never went to law school. If you're trying to understand your lease, your contracts, your custody issues, your employment problems, or court filing because you can't afford legal help, this conversation affects you too. CLEAR also found a real gap between legal education, licensure, and practice. The committee surveyed more than 4,000 judges, 4,000 practicing attorneys, and 600 law students. And the judges, they didn't hedge. 54% of them agreed that new lawyers need more training before they appear in court. 60% said that unprepared attorneys have negatively affected client advocacy. And 67% said that new lawyers only sometimes, rarely, or never apply the rules of evidence appropriately, even though we learn it in law school. The report identified weaknesses in practical advocacy, client communication, applying procedural rules, negotiation, and workload management. And it did something useful for all of us. It defined practice readiness because stakeholders had been using that phrase to mean all kinds of different things. CLEAR defines practice readiness as the knowledge, the skills, and the professional abilities a new attorney must possess to practice independently at a novice level. And it sorts those into 4 categories: foundational knowledge and analytical skills, ethics and professionalism, communication and durable skills, and legal practice skills. Notice what's in that definition. 3 of these 4 categories are not doctrine. They are judgment, communication, professional identity, the things that are hardest to build by reading a case summary. CLEAR made recommendations to state Supreme Courts, but the ones that mattered for this conversation cluster around a few ideas: the realignment of legal education licensure and new lawyer readiness with what the public actually needs. Build practice readiness deliberately before and after admission, including experiential learning that gives students real client responsibility through clinics, internships, and externships. And reform bar admissions to explore innovative pathways to licensure, not just the written bar exam. But the finding that stopped me is the one about how lawyers are actually being made now. CLEAR says that the practice of law is changing under everyone's feet, and only 4% of civil cases and 3% of criminal cases ever go to trial anymore. So new lawyers get far fewer chances at the skills that build a litigator. And then the report says this directly: artificial intelligence is, in its own words, effectively handling work typically assigned to associates, like reviewing large volumes of documents and drafting memos. Sit with that. The court system's own report is telling us that the work that used to teach a young lawyer how to think is being absorbed by a machine. Layer on that the economics. Firms have less capacity to train than they used to because clients are no longer willing to pay for new associates to learn on their matters. And when I was in-house, I didn't do it either. So the apprenticeship is shrinking from both sides. The work that built judgment is being automated, and the budget that funded the rest is being cut. Attention, regulation, verification, judgment, communication, practice readiness. It's not a side issue. Those are not side issues. They are public protection issues. A chronically exhausted profession becomes more vulnerable to mistakes, ethical failures, poor supervision, impulsive decisions, and disconnection from the people it is supposed to serve. And that brings me directly into today's legal blind spot. Today's legal blind spot is sponsored by Legally Lucid. A lot of people are already running parts of their businesses and lives through AI. Their contracts, maybe it's their policies, their marketing copy, pitch decks, emails, leases, court forms, severance, business formation questions. But here's what I know from spending more than 150 hours running real tasks through multiple AI models. They can give you very confident answer while completely missing the issue that actually matters. And the miss can be subtle. The model may answer under the wrong jurisdiction. It may rely on an outdated rule, glide past an exception, build the answer on an assumption that you never meant to give it, or fail to ask that one question that would have actually changed the analysis because it doesn't know. Different drafting assignments, different reasoning tasks, different jurisdictions, different complexity metals. Not one model got everything right. Some were genuinely useful. Some were impressive in narrow context, but missed certain words that were incredibly important. Some were much worse than others. The dangerous part was that many answers sounded polished enough to fool someone who didn't already know what to verify. So large language models, they're prediction systems. They predict likely language patterns based on training data, prompts, reinforcement systems, and context. That means they are optimized for plausible output rather than the guaranteed truth. The model has learned what legal writing sounds like, so it sounds good. It does not understand the law in the way a trained lawyer understands the law. After years of reading cases, after spotting distinctions, applying hierarchies of authority, knowing how to verify authority. That's why hallucinations happen. And a hallucination is not just a typo. It can involve fabricated case citations, non-existent quotations, incorrect legal standards, fake statutes, wrong jurisdictions, or answers that sound coherent while missing a crucial exception, an amendment, or something like that. And people trust fluency, especially under pressure, and especially when they're overloaded cognitively, or they're anxious, or they're inexperienced, or they're exhausted, or they're just trying to move quickly. That includes lawyers. Let me show you how far this has gone, because this is no longer a cautionary tale about one careless lawyer. The most famous early example was Mata versus Avianca, federal case in 2023. 2 lawyers built a brief built on 6 cases that did not exist, but they had names, citations, and quotes attributed to real judges. ChatGPT invented all of them. When the citations were challenged, the lawyer asked the same tool whether the cases were real. And the tool said, yes, they were, but they weren't. The judge sanctioned the attorneys and their firm thousands of dollars. But here's the part that is the problem. The judge didn't sanction them for using AI. He sanctioned them for failing to verify and for misleading the court. The tool was not the violation. The missing judgment was. And the problem has actually exploded. A database maintained by a researcher at a major business school has now documented more than 1,000 instances worldwide of AI-generated fake, misquoted citations showing up in actual court filings, several hundred of them in United States courts, and the count is climbing by several a day. This is not just solo practitioners and people representing themselves. Some of the biggest, most prestigious firms in the world have been caught. Firms with elite training, full research departments, every resource's incentive to get it right, have had to apologize to judges after filing motions that cited cases that don't exist and misquoting the law. And at least one of those situations, the firm's own internal policy told its lawyers to trust nothing and verify everything. And it still happened because the policy wasn't followed and the errors were caught by the other side, not by the firm. So everyone listening, this needs to land for you. If firms with that kind of training and those kinds of resources are still getting this wrong, think about what it means for a small business owner, a self-represented litigant, or anyone leaning on a free chatbot with no idea of what to verify. The people with the least protection, you guys are taking the biggest risks, and the courts are responding. As of early 2026, dozens of courts have issued orders that require lawyers to certify whether they're using AI in preparing a filing and to confirm that a human reviewed and verified it. It doesn't matter if you're representing yourself. So here's what I want you to think about. The penalties have grown. What started as a few $100s and a warning has now become 5-figure sanctions, public referrals, and in some cases, suspension of lawyers. The duty of competence, the duty of technology use, the duty of candor, all of those are violated when lawyers are not verifying what they're supposed to do. Now, this matters if you're a member of the public because you don't even understand this profile. And hallucinations are not just a legal problem. They can also violate confidentiality. So this is part of why the larger issue is epistemic instability. People increasingly don't know what systems deserve trust, which sources are authoritative, or how much verification is necessary before acting on information. So here's the safer way to think about AI. Use it to organize. Use it to brainstorm. Use it to translate dense language into plainer language. Use it to generate questions. Use it to identify the issues you may need to explore further. Use it to create timelines, summaries, comparison charts. Just make sure you double check them before you're talking to a lawyer. That's very different from treating it like your lawyer. And if you're using AI to understand a legal issue, especially if you're representing yourself or trying to decide whether you need legal help, or maybe you're just a novice lawyer, you need a verification process. Don't rely on one chat and one conversation forever, by the way, because long AI conversations will degrade. The system starts to carry too much context, and it may anchor on old assumptions and blend unrelated issues. Maybe it repeats earlier mistakes or answers the question you asked 20 messages ago instead of the one you're asking now. So when the issue changes, the stakes increase, or the answers start feeling repetitive or inconsistent, start a new conversation or a new chat. And when you do, don't just say, based on everything above, because there is no above in the new thread. Create a clean handoff prompt. Maybe something like, I'm trying to understand a legal issue in a particular state or jurisdiction, and then name the state or jurisdiction. I'm not asking for legal advice. I want general legal information, issue spotting, and a verification checklist. Here are the facts I can share. Here's what I already checked. Please identify assumptions, possible deadlines, jurisdictional issues, official sources to verify, and questions I should ask a lawyer. That'll usually produce a much better result than, what should I do? Then you have to actually verify it, especially if you're filing something in court and even if you're not a lawyer. Check every case to see if it exists. Search the actual case name in the citation. You can use Google Scholar, Court Listener, a court website, or reputable legal research database if you have access to one. Check whether that quoted language actually appears there. Check whether the case says what the AI claims it says. Check whether the case is still good law. And this last part is really difficult without a professional research tool because lawyers use citators like something called Shepard's or KeyCite to see whether a case has been reversed or criticized or distinguished, or more importantly, overruled. If you don't have access to those tools, that is a sign to slow down and be really cautious. Get a lawyer. For statutes, go to the official source. Use the actual legislature's website. the federal statute, the agency page, or whatever court rule whenever you can. Check the effective dates. Some things have expired. Some things haven't even passed yet. Check definitions, amendments, related regulations. Check local rules. The rules in Miami might be different than the rules in Tampa. And slow down before uploading any information into AI systems. Anything that is confidential, privileged, sensitive, or identifying information, don't upload that unless you understand the platform's privacy and retention rules. And when your lawyer sends you advice, don't put it in ChatGPT. That gap, by the way, is part of why I built Legally Lucid. Most people don't realize what they're missing legally until something actually goes wrong. So it's a legal readiness platform for founders, nonprofits, mission-driven organizations, consultants, creators, and growing businesses. There's a diagnostic that helps identify where you may need to look more carefully before you sign, hire, raise money, use AI, seek donors, scale, or enter into important business relationships. There's a vault which teaches what to check through education, issue spotting pathways, checklists, templates, go to the source links, and practical preparation tools. And it's an issue spotting and preparation mechanism. It is not legal advice. And one of the goals is to help people who are listening recognize when a situation has become important enough that they should stop relying on templates, or Reddit threads, or AI summaries, and actually get qualified legal help. I am, by the way, opening a small founding beta group now. So if you want to help test the diagnostics in Vault for free, the link is in the show notes. And remember, this segment is general legal education and should not be taken as legal advice. It does not create an attorney-client relationship. If you're dealing with a specific situation, please talk to a lawyer in your jurisdiction who can advise you based on your facts. Finally, before we close, I want to leave you with something practical from my upcoming Illuminated Wisdom Toolkit, which is going to be published in fall 2026. This tool is called the Attention Audit. I want you to use it if you're studying for the bar, you're preparing for exams, you're starting a summer job, you're reviewing a contract, you're building your business, you're preparing a presentation, trying to read a full article now that I've said people can't do it. I want you to try to, what can you do without reaching for your phone every few minutes? Choose one task that requires real thinking and making specific. Maybe it's review this rule, read this book, review this contract. Maybe it's clean the kitchen without touching my phone. Then prepare the environment. Turn on your do not disturb. Turn off your notifications. Close your email. Close Slack, Teams, Discord. Put your phone in another room if you can. And if you're using AI, decide before your work block what role it's allowed to play. And set a timer, just 25 minutes. During that block, stay with the task. And your brain, of course, will want stimulation, novelty, escape, reassurance, interruption. That doesn't mean you're failing. That is what you're training to find out. When your attention drifts, notice it and gently bring it back. And actually, that act of returning is how focus gets rebuilt. At the end, ask yourself, how many times did I want to switch tasks? What pulled my attention away? What helped me stay? Now, if 25 minutes seems impossible, start with 10 minutes. So if this episode helped you, I want you to share it with one person who needs to hear it. If something landed, leave a comment or email me at marcia@illuminatingwisdom.com. I read every email and comment, and I want to hear from you. Now take what you learned today and let it shape how you lead, how you choose, and how you move through the world. I'll see you next time.